For the next speaker, we have with us Mr. Justice Priyantha Jayawardena. We are deeply honored to welcome Justice Priyantha Jayawardena, President's Counsel, a distinguished jurist with a remarkable career spanning over 3 decades. Having served as a judge of Supreme Courts of both Sri Lanka and Fiji, he brings unparalleled expertise in commercial law, arbitration, and judicial reform. Justice Jayawardena has held numerous influential roles, including state counsel, legal consultant, and academic, and was also instrumental in shaping key legislative frameworks such as Consumer Affairs Authority Act and the Electronic Transactions Act in Sri Lanka. Now, serving as an arbitrator, his continued contributions to the legal and ADR communities remain invaluable. We cordially invite Justice Jayawardena to share his insights on ADR landscape in Sri Lanka and grace this occasion with his presence. Over to you, sir.
Thank you very much. Good afternoon, everyone. I hope you all can hear me, right? Can you hear
Yes, sir.
me?
You're audible. Yes, sir.
Right. It is a great honor to address you today on dispute resolution. Before I commence my presentation, may I take this opportunity to thank Kovise Foundation Conflict Resolution, the organizing committee of the webinar, Sri Lanka National Arbitration Center, and its Chief Executive Officer for giving me this opportunity to address the webinar. As society becomes more connected and complex, the traditional means of resolving disputes have often struggled to keep pace with the demands of our digital age. Today, we will explore how alternative dispute resolution can be more efficient, accessible, and transparent in resolving disputes. Dispute resolution refers to the process of resolving conflicts between parties, and it comes in various forms such as litigation, alternative dispute resolution mechanism such as negotiation, mediation, conciliation, and arbitration. Negotiation is a simple form of dispute resolution, as it does not require the involvement of a third party, and the dispute can be resolved between parties among themselves. On the other hand, mediation is conducted by a mediator who facilitates the discussion between the parties in order to resolve their dispute. Conciliation, which is similar to a mediation, involves a counselor who enables the parties to reach a mutually agreed settlement. The difference between conciliation and mediation is that the conciliator provides solution for the dispute, whereas the mediator merely facilitates the parties to reach a settlement among themselves. Arbitration is a form of resolution in which the parties avoid court proceedings and instead decide to resolve their dispute by appointing a third party who is named as an arbitrator. In arbitration, the arbitration or the tribunal evaluates all the evidence presented by the parties and arrives at a decision called the award, which is binding on the parties. Traditionally, these procedures have been human-centric, requiring extensive manual labor and face-to-face interaction. Alternative dispute resolution is almost as old as civilization itself. Traditionally and historically, depending on the type of dispute and the parties involved, family elders, members of the community, or local leaders would often help resolve any issues or disputes. The formal recognition of the traditional alternative dispute resolution mechanisms by the modern legal systems can be traced back to British era legislations. It is same in India and also in Sri Lanka. We started the alternative dispute resolution arbitration provisions in the Civil Procedure Code. Actually, the Sri Lankan Civil Procedure Code is almost similar to the Indian Civil Procedure Code enacted at that time. Of course, now the Indian Civil Procedure Code has developed and changed. But we are still using the same Civil Procedure Code with certain amendments. However, in Sri Lanka, we have repealed the arbitration provisions in the Civil Procedure Code and introduced a new act in 1995. Advantages of alternative dispute resolution are faster, less expensive. Of course, now it's becoming more expensive and we need to come up with some kind of solution for that. But in Sri Lanka, certain institutions, arbitration institutions have come up with a fee structure so that the arbitrator can is entitled to claim only that amount, even if the arbitration proceedings get prolonged. So as a result of that, everyone would try to finish it within the stipulated time, that is within a year maximum. Then it's confidential, informal, may involve significantly less procedural complexity than that of court proceedings. It helps the parties to maintain their commercial or personal relationships even after the dispute is resolved. Now, in Sri Lanka, there are instances where there will be one agreement with an arbitration clause, but several activities take place under the same agreement. It's like an umbrella agreement. So even if there is a dispute in one aspect of the agreement, but while the matter is being arbitrated, the rest of the agreement and the functions will continue as if nothing happened with regard to those issues. So that's the biggest advantage in the Sri Lankan perspective. I think it's the same in other jurisdictions as well. However, there are certain instances where the council have thought it's prudent to seek the assistance of court instead of coming to the arbitration, taking into consideration of the complex legal situations and the practical problems. The basic prerequisite for arbitration is that it must be, parties must agree in advance or after the dispute arose to refer the dispute to arbitration. That is something unique. That's a unique provision because it is not necessary, but in certain jurisdictions, you need to have an arbitration agreement to refer a dispute to arbitration. But in terms of the Sri Lankan Act, even after a dispute arises, notwithstanding the fact that there was no arbitration agreement, the parties can agree to refer a dispute to arbitration. Of course, you need to have a written agreement to refer the matter to arbitration. The arbitration agreement is like any other contract, which needs to fulfill certain requirements. For an example, the capacity to enter into the arbitration agreement. In this regard, I like to share my experience as a judge. There was a case which came before me where at the time the parties entered into agreement, they have not named the proper parties to the agreement. Technically, both parties were companies, that is with regard to road construction, but the person who drafted the agreement referred to one party as a sole proprietorship, notwithstanding the fact that it was an incorporated company in Sri Lanka. That's a Chinese company, but incorporated in Sri Lanka. Majority shares were with them. Then, when this Chinese company initiated arbitration proceedings, the respondent took up the position that there was no valid arbitration agreement because the party who signed that was not a legally recognized person, not a juridic person, namely. So the arbitral tribunal held with them, and finally it came before the Supreme Court, and the Supreme Court affirmed the decision of the arbitral tribunal. Now, how long I have? May I know how long I can go on? How long I can go on?
Sir, you have 5 to 7 minutes, sir.
How long I can go on? All right. Then, like in India, we have the appointment. It's actually in Sri Lanka there is no need to have any qualifications to be an arbitrator. But as a result of that, retired judges, accountants, engineers, and various other people are appointed. But it's always better to have a legally trained person to chair the panel for the reason that it involves evaluation of evidence and also the procedural aspects, and quite often certain legal issues will also arise. Like in India, of course not by the Chief Justice. In Sri Lanka, if a party doesn't appoint an arbitrator, the other party can go to the High Court and ask the court to appoint an arbitrator. The other thing, important thing is, a lot of people, it is very important that at the time the agreements are drafted, the agreements should be drafted very carefully. What a lot of people do is they just copy it from someone else. And when a dispute arises only, they will see the problems. Now, one has to be very careful when they decide the seat and the place of arbitration, because they have two different meanings. Due to time constraints, I don't want to go into those ones. I will just go by, I will only refer to the relevant points only. And also, if there is a arbitration agreement under our Act, the courts have no jurisdiction if the other side goes and object to the jurisdiction of court. I think it's same in India also. But the difference is, under our law, it's the courts have no power to refer the matter to arbitration. All what they can do is they can dismiss the case. It's up to the parties to go to arbitration. But at present, we are considering, Sri Lanka is considering to introduce a system where the courts on its own, whether there is arbitration agreement or otherwise, will have to give power to courts to refer matters to arbitration or mediation like in Singapore. Also, it's the same in America. And those have been very result-oriented. Then, like in India and the region or any other country, we have the doctrine of competence. Competence is applied in Sri Lanka with regard to the jurisdiction of the tribunal, where the jurisdiction can decide. Unfortunately, under Sri Lankan law, if the tribunal decides that it has no jurisdiction to hear the matter, there is no right of appeal. So that's the end of the matter. So I have written a judgment in this regard. We have a similar provision like in other jurisdiction where it says that if the award is final and binding on the parties. So therefore, we have considered that aspect and here that it's almost similar to the doctrine of res judicata. So they are after, if somebody takes up, if recently there was arbitration which I did, the respondents, it was an insurance matter with regard to the refusal to pay a claim. Of course, there was arbitration agreement, but that refers only to the disputes with regard to the quantum. So this was a case where they have refused to entertain the claim. So when the other side took up that position, objection, the claimant withdrew the proceedings, reserving the right to refer the matter to institute action in courts, which was allowed, and so that helped them to overcome the difficulties with regard to res judicata. Now, the latest thing is when it comes to international arbitration, we use new technology. The issue is with using technology is mainly to have video conferencing and like that. So there are various problems arising from that. The speed, the honesty of the parties, whether they are being coached during the cross-examination or evidence in chief, and how. So in that context, I think it's better if the international community get together and come up with a set of rules which will help or a model law or model rules which will help the other countries to enact corresponding legislation or the rules with regard to using technology for arbitration. It could be local arbitration or international arbitration. When it comes to mainly our local arbitrations are done based on ad hoc procedures, but when it comes to international arbitration, we follow ancestral arbitration rules or the other various international procedures and rules. Now, Now, when it comes to, since there is now I have almost come to the end of my time, I will try to wind up. Enforcement, our arbitration agreement act recognizes foreign awards. So it can be enforced in Sri Lanka, any foreign award. We have not specified what is an award. It's one can get a broad interpretation to any award, whether it's commercial or otherwise. It can be enforced in Sri Lanka. And our section 31 specifies the procedure for enforcement of the arbitral award, and section 32 specifies how to set aside an award. Now, enforcement, people, the claimant has 1 year and 1 day to file enforcement applications. But the respondent who wants to get the award set aside, he should file it within 2 weeks. For late Justice Prasanna Jayawardena and I have written a judgment which says that if a person doesn't exercise their right to set aside an award within 2 weeks, is not entitled to resist the award at the time when it is enforced. Of course, it is subject to certain restrictions which are set out. The main distinction is that Sri Lankan Arbitration Act is set out basically the main points, unlike the Indian one or the other jurisdictions. I think, in my opinion, the Indian Arbitration Act is better compared to the Sri Lankan one because it is more comprehensive and the positions are more certain. We go by mainly the jurisdiction, the jurisprudence of previous cases, how the courts have interpreted these agreements. But the other thing is, in Sri Lanka, we don't apply the Civil Procedure Code or the Limitation Act, which is in Sri Lanka, we call it prescription ordinance. But we have a similar provision which allows, which says that one should come to arbitration within a reasonable time. So in such circumstances, the tribunal can see why, if there is a delay, whether that delay is justified. Now, the Sri Lankan courts facilitate the arbitrations and the enforcement procedure. It doesn't take a restrictive view. We take a broader perspective and try to facilitate arbitrations. And the government also try to encourage arbitration. In fact, the Port City Act, the Colombo Port City Act says by law, if there is a dispute, it should be referred to the port city and an investor, it should be referred to arbitration. And also, we have said our law, you need to file the arbitration agreement, but it's not necessary to have file the original agreement, but filing a certified copy is sufficient. Because as I earlier mentioned, we have different types of different disputes can arise under the same agreement, and those disputes can come up at different times. So therefore, it's not practically possible to file the original in court at the time of enforcement or to set it aside. So therefore, actually, I have written a judgment where it says a certified copies would fulfill the requirement of the Sri Lankan law when it comes to enforcement or to set aside an application. Our main issue, I will conclude with this, my personal opinions, few suggestions. My personal experience is that, thank you, is that, excuse me, is that we lack an institution which trains arbitrators and counsel. I've seen instances where counsel, actually I myself has appeared as a counsel in arbitrations before I joined the judiciary. Counsel present his case as if he is presenting a case in court. There's a vast difference in the appearing in court and in arbitration. So sometimes in arbitration, the counsel can be very aggressive like in court, or take up various technical objections. So those are things, so I think those are real issues that needs to be addressed, and there has to be an institution or a process where we train arbitrators and the counsel both. So that's the main thing, in my opinion, that requires to promote arbitration, because there is a trend in Sri Lanka. The people are now trying to go away from arbitrations because of the long delays and the fact that sometimes the tribunals are being converted to courts. So those are the main things that I have to say. Thank you very much for giving this opportunity. If there are any questions, I should be able to take one or two questions.
Justice, now we have a question from Sebastian Thiels, which is as follows. Your opinion on the potential economic and political risks in Sri Lanka being a stifle for the country's development in international arbitration, and how it can be overcome.
I think as far as when it comes to commercial matters, international commercial matters, to overcome the problem of claiming sovereignty, we have included, because when I was serving in the Attorney General's Department also, we included a clause which says that the agreement would be considered as a commercial agreement. Or there are certain instances where we have specifically said we will not plead sovereignty when it goes to arbitration. And also, as far as I can see, the main object of the successive government in Sri Lanka is to promote commercial activities and to attract foreign investment. So in that context, I think we leave politics from and the arbitrations or the litigation will be handled in a different perspective. So there won't be any interference with regard to those matters. And also, even the government contracts, certain instances we have agreed to go to have Singapore or England, UK, as the seat of arbitration.
Thank you, Honorable Judge of Sri Lanka and Fiji. It's a very insightful session what you had now, and we are very, very happy on behalf of KFCRI. We thank you once again for sparing your valuable time, particularly facilitated through the Sri Lankan National Arbitration Center and the registry. Thank you, sir.
Thank you very much. It's really appreciated. Thank you.